Let's get started. First of all, to Lorna, thank you very much for inviting me to address your group. I must tell you that we have had the experience of dealing with a number of retail jewelers and a couple of manufacturing jewelers around the country since we've started the South African Independent Tenants Association movement to really try and balance out the representation for something that to date, quite frankly, has been absolutely imbalanced in shopping centers, but also in commercial rentals around the country. And when I say imbalanced, I'm really saying ultimately at the end of the day that the retail tenant, the commercial tenant, really has been victimized very often by landlords, although there are an increasing number of landlords that are beginning to realize how dependent they are on small retailers and are coming to the party in quite significant ways, I must say. So we're starting to break through that problem and that quagmire. But I'm very, very grateful to Lorna for inviting me to address you as the small independent tenants, and for Debbie as well for initiating this activity. So let's get to it. What I want to address today are the following three areas. I want to talk about the lockdown, the notion of what essential services was under level 5 and what it is under level 4, and how you should be applying that within your businesses. And there we'll talk about the 29th of April disaster management regulations, and how they affect you in terms of retail and how they affect you in terms of manufacturing. I also want to talk about, I think, what's on everybody's lips at the moment, which is TERS, the Temporary Employee Relief Scheme. I think that TERS is going to become the new universal basic income grant in South Africa after lockdown is lifted. And really, what TERS has been initiated as was to test out the playing field for what a basic income grant will look like in the future for those individuals who, for a variety of reasons, including COVID, but also including the advancement of technology, will not be able to get jobs and will, in fact, will have to stay at home in some form or another for some period of time. I then want to talk about dealing with landlords and managing agents. I want to talk about the legislation which was implemented by DTI to allow those discussions to take place. And I also want to talk a little bit about how we as CITA, the South African Independent Tenants Association, are advising our members to deal with your landlords, and the rights and the wrongs and the ins and outs of those approaches. And then I want to talk about dealing with Department of Trade and Industry and the various aid and relief packages which are available, and what we are suggesting in terms of the COVID approach to DTI, as well as after that, after COVID has been lifted, what we're suggesting, particularly to associations such as the Jewellery Association, which we think should be receiving a large proportion of the funding which is available from the Department of Trade and Industry on the supply side, not only to encourage manufacturing, not only to encourage retailing, but also to encourage export of product which emanates from South Africa. I do not think that the jewellery sector, the creative, the innovative jewellery sector in South Africa is given enough recognition by the Department of Trade and Industry in terms of taking your product globally. And yes, there are a couple of very, very successful jewellery designers and manufacturers in South Africa who have gone on to conquer the world. But I think that it should be done on a much larger scale than is currently the case. And that's why I was so encouraged by Lorna's invitation to me to address you. And then we'll go to some very general questions and answers. I do want to encourage you, please, to use the chat facility. And please feel free to type in any of your questions or all your concerns or considerations, or unmute your microphone and literally just have a go at the microphone and tell us what your question is and what you're thinking. So again, thank you very, very much to Lorna for asking me to participate in this session today. And let's in fact then get started, ladies and gentlemen. I'm just doing this quickly because I want to call something up. There we go. This is what I want to call up. I take it that you have all seen this document by now. This is the document that, in fact, is in its fourth version. And this is the document which has been government gazetted and directs how we are implementing the disaster regulations since lockdown has commenced. The government department which controls the implementation of the disaster regulations and legislation is the cooperative governance department, and that falls under Nkosazana Dlamini Zuma, Jacob Zuma's ex-wife. And I'm sure you will have seen her on television. If you're a smoker, I am virtually certain that you have a dartboard with her face on it at home. So you will have noticed that this document now in its fourth version is significantly different to how it looked when we were where we were subjected to a level 5 alert level up until the beginning of May. Um, I'm just quickly muting microphone just to make sure that there's no background noise coming through. I think what's very, very important about this document is that it says everything that you need to know about the lockdown. And so there are a number of self proclaimed experts out there who are running around and charging to explain to you our state of disaster, and even charging to implement in your workplaces workplace plans, standard operating protocols and procedures, etc. If you read this document, and Lorna, I might suggest that maybe there should be almost a jewellery manufacturer and retailer guide to understanding this document. It could be very, very useful for you to just put out to your members. But essentially, you all know that we have 5 levels of alert in South Africa, and you all know that we've moved from level 5 to level 4 now. And what's important in that moving of level 5 to level 4 is, in fact, what appears from page 25 onwards. And by the way, the alert levels are explained all the way through the document. But from about page 25 of the document, it becomes essential reading for you, 24. And that's where we've got our table 1, which is alert level 4. And it explains to you then which industries can start coming back into operation. Now, what I do want to say to you is that you need, ladies and gentlemen, to be very aware of the fact that under manufacturing, manufacturing jewelers will in fact come under Part C, level 9, or Part C, number 9, which says you don't fall into the construction sector, you don't fall into the stationery sector, you don't fall into the motor car sector, into the clothing sector, into the chemical sector, plastics, paper. But where you do fall is under 9, which says all other manufacturing scaling up to 30% employment and subject to strict health protocols. So number 9 is critically important, and there are 2 issues to do with number 9 we need to talk about. The first is that in the first version of this document, which was literally 2 or 3 days before this document was published, that 30% actually read 20%, which means that at that stage they were saying that if you were not in 1 to 8, any of the sectors of 1 to 8, but you were a manufacturing jeweler, you would be entitled to scale up to 20% employment. In other words, employ or bring back 20% of the people who work for you, subject to strict health protocols. Now, there are 3 things implied in that statement, not 2. The first is that if you are able to run your manufacturing operation on 30% of your staff, but run 100% of your manufacturing operation, then you are fully entitled to do that. The second is that you are required to not exceed 30% of your workforce in your manufacturing business. And the fourth element is the notion of what scaling up means, because scaling up is a definable process. And scaling up says that there are 4 stages to, in fact, coming back to work. four stages to opening your workplace. Stage one is where, with a very small skeleton staff, you would come into your business, you would clean your business, you would put into place standard operating procedures and protocols, you would put up posters around the workplace in terms of what is required in terms of those standard operating protocols, explaining social distancing, explaining hygiene. You would put into play a sanitizing process of the workplace. And so your first activity, and let's say it was done on the 4th of May, Monday, the 4th of May, because that would be the first working day you could have done it. So you'd start on Monday, the 4th of May, and you'd start with this process of getting the workplace ready with a small skeleton staff. You would then bring back the first 33.3% of your workforce. Now, that might be 2 people, it might be 33 people, depending on the size of your workplace. And you would slowly start inducting them into the new standard operating protocols to make sure that they were socially distancing. You would assess them in terms of their knowledge of your protocols. You would assess them in terms of their behavior, respecting hygiene and social distancing. And then you would bring back the next 33%. And there could be a couple of days between the first 33% and the second 33%, or in fact, it could be months. I have some clients who say that they will bring their staff back, and the gap between the first 33 and the second 33 will be a month. Some say 2 months because of what they anticipate the lockdown to look like. And it doesn't really matter. And it doesn't really need to be exactly, a third of your workforce, especially in the smaller businesses. And you're not expected to do this in a business that employs less than 10 people like this. You could split it into 2 groups, for example. Not 1 group, though, and I do need to emphasize that. So you would scale up to eventually having 30% of your employees back at work, but it can be 100% of your business if you can run it with those 30% employees. I know that there was and I spoke to Lorna about this. There was this misunderstanding that somehow you believed, or some of you as manufacturing jewelers believe, that you fall into the steel sector, and therefore that you could scale up to 50% of your employees. I'm sorry to disabuse you of the notion. You do not fall into the steel sector. And there's absolutely no way on earth that you could justify that you fall into the steel sector. So you very much fall into the other manufacturing category, which is jewelry design, jewelry manufacturing, and the supplying of retail stores that retail jewelry in South Africa. And you very much are expected to keep to that 30% there. Again, let me say, if there's any questions, please come online and just ask your question, either by going into the chat facility or just unmuting your microphone. Now, the next place you need to look at is here, part E, because if you're a retail jeweler, in other words, you're not manufacturing, but you're simply selling. If you're a retail jeweler, then you have a problem. And your problem is that you do not have the right to open the doors of your retail jewelry store. You do not have the right or the license to open the doors under level 4 of your retail jewelry store. Now, I did receive a question yesterday from someone who said that if Becca Kelly is right and we are about to go down to a level 3, and level 3 indicates an increasing number of retail options, or level 2, will we be able to open our stores then? And the answer is absolutely. If you fall into any of the categories where at that particular alert level, you are entitled to open your doors, then you're entitled to open your doors. You have to obey the same 4-stage process, sanitizing 33, 33, 33, but that's how you would open your doors at that stage, but not now. So this is critically important. You cannot open your doors as retail jewelers. You would need to get a BizPortal CIPC certificate, and you will not qualify. There's nowhere here where you can point to the fact that you're entitled to open your doors for this purposes. And more importantly, no store which is an essential service store, such as a Dis-Chem or a Pick n Pay, etc., is entitled to be selling retail or retailing jewelry within their store. So if they used to do it, they have to close off that section, and they need to know about that. However, what is very interesting here is point number 20. where under certain circumstances, you may be permitted to develop an online e-commerce business and deliver jewelry for birthdays, for wedding anniversaries, etc., to those people who order the stuff online. There is a move afoot by um, brick and mortar retail businesses to force the Department of Trade and Industry to restrict e-commerce business, such as Takealot, to only essential services product. And you can understand why, because these guys are saying, well, we don't have an online business. We are very much a retail store. And yet the online guys will decimate our business if they're allowed an opportunity to compete with us when we're not allowed an opportunity to practice. The Department of Trade and Industry has been very wishy-washy about who under the e-commerce umbrella is allowed to practice and who's not allowed to practice. So a practical example, and I was telling Lorna this the other day, but a practical example is what we've done with floristry, retail florists who are not allowed to open their stores in shopping centers and open their doors and allow people to come in and buy flowers from them. But what we've done is we've created an e-commerce portal for them so that the essential service product, and flowers are listed as an essential service, farmers can pick them. They're part of the agro processing sector, but mostly for export. But so that those can be sold online with value added, so that because Net Florist, for example, was operating, Blooming, whatever, was operating online, but the retail florists weren't allowed to operate online. So we created an e-commerce platform for them, and they're doing very nicely now. They had a great day on Sunday for Mother's Day, and that's working nicely and working well. And I'm sure, by the way, those of you who have an online presence are already trading online in terms of e-commerce. And I'm sure you had a fantastic Sunday in terms of having orders coming in and deliveries as well. Conrad asks a question. What about where your retail shop and manufacturing shop is on one premises? Can the retail items be packed away and just service customers with manufacturing needs? Absolutely. So, Conrad, the bottom line is you would be like Discam. You would literally have tape over the retail side of your business, and but the manufacturing side of your business can very much be opened. I know around the corner from me in Norwood is lasers. I know there's a certain amount of repairs that could be classified as manufacturing going on at the back of lasers. And the bottom line is that even though it's uncomfortable because you have to walk through the retail section to get to the manufacturers at the back, it's not impossible to consider that you could very well open for that purpose. Deepika says, to confirm, can you deliver the product ordered online? Oh, absolutely. What a beautiful question, Deepika. Okay, so my answer to you is twofold. Number one, you do not have to use a courier to deliver product from an e-commerce business. You can do the deliveries yourself, but if you want to use a courier and pay, I don't know, 25 or 40 Rand, whatever it is, some even up to 100 Rand, then you're fully entitled to use a courier. But there is no requirement that even for takeaway businesses where there's ordering online, they have to use a courier service. There's no legal requirement for you to have to use a courier service. You can do your own deliveries of your own product, which is ordered online. So thank you for that question. Mariella Mulman asks, please clarify, are we allowed to courier jewelry? Yeah, courier the stuff. Bottom line is the manufacturers, the other manufacturers who are entitled to open under C9, the other manufacturing, scaling up to 30% of employment, will be entitled to manufacture and will be entitled to courier. And equally, under E20, the e-commerce businesses that take orders online will be able to courier and deliver to people. Bottom line, bottom line. Now, this isn't to say that you're not going to have trouble from the South African police services or the South African Defence Forces, who are going to either shut you down or try and shut you down if they feel that you haven't got the right certificates. But I would appeal to you, Lorna, and I can put you in touch with the people at Interflora to find out how they did it. But they basically got a blanket authorization to allow their Interflora retail florists to set up and to work from their stores without opening their doors or to work from home and to be dispatching from their businesses. And so you would carry a certificate from the Jewellery Council, as an example. The Jewellery Council would have an agreement with BizPortal or the CIPC to allow you to do that. And you would then activate the e-commerce side of every one of your businesses.
Ivor, may I ask a question, please?
Of course, Chris. Yes, thank you very much. It's so nice to know there's somebody else on the other side.
So the question, or I've received quite a few mails from different courier services, and they stress that they are open for business and are only allowed to courier and deliver permitted goods.
Yes.
Now, under permitted goods, jewelry does not seem to fall under that, although you're saying if we manufacture, we are allowed to trade, entertain clients to come to our factory facility.
No. So Chris, let me correct that assumption. If you manufacture, up to 30% of your employees will come back to work. But you have to have a standard operating protocol that says that you are manufacturing without running a retail business. In other words, you're manufacturing
for sure,
because
but,
you're taking orders. Sorry, yes?
But you still have clients, trade clients, as a trade manufacturer, that will bring you the orders. Or can they only be online?
It is better. It is preferable for you to do it on a remote basis. If you need to see a particular product, then they can very definitely bring you the product and leave. You should have a box that allows them to deposit it. In other words, as you open your business, you have to have a standard operating protocol in place. And that standard operating protocol has to make it very, very clear that you're respecting hygiene and you're respecting social distancing requirements. As long as they keep to those requirements, as long as you have posters explaining what the requirements are, you can run your manufacturing business that way. It doesn't only have to be internet ordering or ordering remotely. However, if people are going to come to your workplace, you have to make it very, very clear to customers, standard operating protocol on your walls, outside your shop, that says this is how we will allow you to come into our business.
All right, and then the other point that I made, that the courier services and their circulars on email specifying that they will only be able to courier permitted goods.
Okay.
They're
quite correct. They are absolutely correct. Now, what you will do is if you're a manufacturer under 9, Part C9, is what you will do is you will apply through bizportal.gov.za for a certificate to say that as an other manufacturer scaling up to 30% of employment, you want a permit from BizPortal, and you'll apply under C9 on bizportal.gov.za, and that will then give you the certificate, which if you want to, you can say to a courier, here's our BizPortal certificate. Our product is under the other manufacturing category, and we want you to deliver. And as far as our trade is concerned, our trade is under E20, which is e-commerce, taking into account, et cetera, et cetera. And so you would set up that kind of a protocol, although I would appeal to Lorna to do it on a group basis for you rather than, and sorry, Lorna, I'm not trying to put work into your territory, but it's much easier for her to do that. I would appeal to her to then set up as the principal place for BizPortal to engage with on issuing of those certificates, and maybe to talk to Sharon at Interflora to find out how she did it for the retail florists. It's just a very useful way of going about it.
Sure, will do.
Okay, excellent.
Okay, thank you, Ivor.
Thanks, Chris. And please feel free to keep asking the questions. I know it sounds like I'm avoiding you or answering you, but it's an art, not a science, unfortunately, if I can put it like that. What is critically important, though,
So sorry, if I can just at this point, just while we're on that, so a retailer can set up an e-commerce website and deliver?
Yes, if you look at Part E, it says, the incremental expansion of e-commerce, taking into account the need to limit extent of movement on the road, contact between people, law enforcement challenges, and impact on other businesses.
But now when you go to the CIPC website, you are registered there as a retailer. So the information under what would you then apply for this permit on the SIPC website?
So if you're a manufacturer, then it would be as a manufacturer. If you under SIPC, if you're a manufacturing jeweler, you would be registered as a manufacturer.
No, but a pure retailer.
If you're a pure retailer, then you wouldn't apply under the website. If you're a pure retailer, the Jewellery Council would go to the DTI and say, under Part 20, Part E20, we want authorization to give certificates instead of BizPortal, to give certificates to our members under E20 for setting up e-commerce businesses. And I just want to use the narrative here. So taking into account the limit of movement on the road, we're not expecting our customers to come to us, and we will simply deliver to them. Contact between people. The fact is that there's going to be no contact except between the staff members and who are basically working from home and dealing with everything over the internet. As far as law enforcement challenges is concerned, and this is a point I was getting to, what I would do is I would, once you've communicated with DTI and DTI have said to you, okay, we will classify retail jewelry as e-commerce business. Once you've got that directive back from the DTI, what you can then do is you can then take it to any police station. So, for example, Sandringham Police Station, which is around the corner from me, you would see the station commander. You would say, here is our letter back from Department of Trade and Industry. We are now listed under E20 as essential product, essential services, and we would please like you to give us what's what I'm looking for? I've forgotten. It just starts with a P. A permit. We would please like you give us a permit to say that the police can't close us down if they find that we're open, but only for purposes of e-commerce. And once you've got that, you are fully allowed to trade then. You're fully allowed to take that to the courier companies, and they have to accept that, and they have to deliver your product. So it is a process. It's not automatic. But what they've done is they've in creating E20, they've allowed you to extend the definition of e-commerce. And sorry, there was another thing I wanted to answer in terms of the narrative, and that is impact on other businesses. What you would be saying to them is, we are not asking for authorization to set up an e-commerce business, which is a new business. We are retail jewelers. Here is our lease as a retail jeweler. The e-commerce element is simply an extension of our business, and therefore we are not setting up an unfair competition with other retail jewelers. First prize for us is still to be a retail jeweler rather than an online jeweler, but unfortunately, because of social distancing and everything else, we're not able to do that. And that would be your narrative, and it's very unlikely the DTI would say no to you in that particular regard. What you could do, by the way, in the process, when you do have the discussion with the DTI, you can also say to the DTI, but however, we would like you to restrict other e-commerce businesses that have never been in the business of jewelry manufacturing or jewelry supply from, in fact, trading in jewelry as an essential service, because that is unfair competition to us. And you can point to Net Florist, you can point to Take a Lot, etc., and you can say those businesses were never in the business of selling our jewelry, and therefore we think it's unfair competition for them to be allowed to sell jewelry when we're not allowed to be trading in jewelry. So you can in fact have that discussion with DTI. And Lorna, I would recommend that you do have that discussion. You might find in the beginning that they say no to you, but you've just got to keep knocking on that door until they say yes to you. The reality is you've also got to sometimes play unfairly. There are some industries that have had to go to the Trade and Industry Portfolio Committee. There are some of you who have very high-profile clients in government. You might very well have to knock on Nkosazana Dlamini's door and say, please, you know, remember I sold you that brooch. Could you please speak to the Minister of Trade and Industry, and could he please speak to the DG and get e-commerce jewelry services to be allowed to trade, because our businesses are dying and we are dying in the process. So that would be the nature of that communication. I'm just going to take one or two other questions.
So this is not a simple process. It's not a fait accompli. You can tomorrow go get. It's almost. Is there any precedent set yet that one can then refer to?
I just gave you an example. I gave you the florist, for example. The retail florist is a precedent.
Okay. So as an association, we can then apply to DTI to get blanket approval for this process to be flawless, because our members in the Jewellery Council, retail members, so far have not been able to trade e-commerce, or were under the impression they can't. because nobody's acquired this license from DTI or permission or permit from DTI, as you are mentioning here. So you're going to have to hold our hand on this process, because this is very, very urgent for our members in the Jewellery Council, for the retailers to be able to start trading, because, like you said, we don't know what level we're going to be fitting into, and even if it's level 3, we don't know when that's going to happen.
100%. I'm with you 100%, Chris. And I'm not going anywhere, if I can put it that way. I'm here to stay. Bottom line is I'm a resource for you. Okay, so moving on then. And thank you for those comments. I really appreciate it. I just muted everybody's microphone just because of the background noise. If you do want to speak, just please feel free to speak. Murali asks a beautiful question. So as manufacturers, can we export too? Absolutely, Murali. The export market is absolutely wide open to you, and in fact, you would look to Part J, and you would also look to Part M. In other words, transport, storage, and communication services, Part J, and you would look to supply chain as Part M. Very much. To be able to export, and you fully are entitled to export. It is the one area, by the way, Lorna, that we must think about using in our discussion with the DTI, not just for lockdown, but it certainly will help to influence for lockdown in terms of the exemptions we want them to make, but also in terms of an export council status. Chris, Lorna, if I can just ask you, and please, I'm not trying to put words into your mouth, but historically, has the Jewellery Council got export council status from Department of Trade and Industries? It was a question, by the way. It wasn't rhetorical.
We've been part of, or we are part of the Export Council at the DTI.
Which export council?
Oh, Chris, can I just interrupt there?
Yeah.
We currently listed as a joint action group, a JAG, at the DTI, because our industry is so small, we can't apply to be an export council at this point in time. But we do enjoy the benefits of taking groups of jewelers overseas and that kind of thing. So yes, we are
Lorna,
informal.
When we're beyond this stage, sorry to keep interrupting. When we're beyond this stage, I want to get involved with the Jewellery Council in making sure we get you proper export council status, because the bottom line is that the only reason they would say to you you're too small is because they haven't given you supply side incentives. Now remember, there are billions of rands of supply side incentives which are available to promote manufacturing, to promote local sourcing, etc., etc. And if they're saying you're too small, it's because they haven't given you supply side status to grow your sector. And more importantly, that they haven't created the corridors for you in terms of supply chain to be able to export into the various retail outlets in Europe and around the world. But what they have done is created the opposite. They've allowed for the import, particularly from BRICS, and that's China and India in particular, but also Russia to some extent, of product which is available, cheap product, which is available on the South African market. So there's been an imbalance there. And what I want to do with yourself and with Chris and the rest of your council, Lorna, is to actually show you how to play the hard game with these guys. Because if you don't play the hard game, you're going to get nowhere with them. You see, EMEA is open to any industry. Any company, in fact, can apply for EMEA funding. And what EMEA funding, and they can't say no. What EMEA funding is, it's to allow you to take your product overseas to trade shows, et cetera, et cetera, et cetera. That's not what the true export issues are. The true export issues are getting the funding to work through the permit structures, the courier structures, the design structures, the material structures, et cetera, et cetera. And so DTI owe it to you, and I'm not grandstanding, but I know the games they play. They owe it to you to invest in your sector like they haven't done before, particularly because it's an indication of an industry that can show absolute transformation for the country as a whole in terms of where you can pick Jewellery Council members up from. So let's get to that as a discussion once we get beyond this immediate thing. But please, don't forget about it. Put it on the agenda for a discussion.
Thank you. Thanks, Ava. That's great.
All right, good. Okay, so moving on, ladies and gentlemen, I just wanted to go to another part of this document here, and it is right at the back here, and it is Annex E, which is your workplace plan. Now, if you're going to open any part of your business, then you have to write up a workplace plan. But you don't have to buy. I mean, they're available for 4,000 Rand, for 5,000 Rand, standard operating protocols for your business, with workplace plans written up for you, etc., etc. But if you just don't want to spend 4,000 or 5,000 Rand, then this is all you have to have in a workplace plan. It's here in the Gazette. It says just draw up a plan that you can communicate with your customers, you can communicate with your staff before you bring them back to work about these things and about how these things are going to work. About the fact that, they have to keep 1 meter or 2 meters between them, etc., etc. But just draw up a plan and have a plan so that if you are raided by the Department of Labor, and unfortunately the Department of Labor have just appointed another 200 or 300 inspectors. But if you're raided by the Department of Labor that are looking to close down your business, and I'm not saying that, I'm quoting the minister, they want to find businesses they can close down, then you can literally show them the workplace plan. You can literally show them videos of you explaining to your staff how the plan should be worked, how social distancing in the business should look like, how they should control, customers coming into the workplace, etc., etc. You can show them posters on your wall and on your windows, etc. So just understand that as Chris said, it is a process. It's not a simple thing. But even in terms of opening your business, understand that the Department of Labor is looking to send their inspectors out to shopping centers and in manufacturing environments and trading environments and looking to close you down. And again, I'm saying, I'm quoting the minister. I'm not just saying that myself. Okay, moving on. So let me just set this up again so that it at least looks presentable. All right. I want to now move to your relationship with your landlords and your managing agents. And as we know, the managing agents are the puppets of the landlords, or sometimes the landlords are the puppets of the managing agents. You never know who's running who. And in fact, the managing agents very often have more lawyers and accountants that they employ than the landlords do. But between them, they're a little bit like in Les Mis, they're the pub owner and his wife. But essentially, in March, the Department of Trade and Industry did what they call a block release. Because before that block release, there was competition law in the country that made it impossible for landlords to talk to one another, for associations to talk to one another, and for tenants to talk to one another. Because the Department of Trade and Industry, the Competition Commission in particular, viewed that as collaboration and viewed it as an environment where collusion was taking place against the interests of the consumer. So in March, what they did is they implemented a block release for the property sector. And in implementing a block release, they made it possible for landlords to talk to one another, tenants to talk to one another, to create associations and to be able to engage. To engage specifically, and I quote here from Mohammed Vorda, I put him on the back foot. I wrote to him and I said, you implemented these regulations and they're now coming back to bite my members who are the small independent tenants. And he said, but hold on a moment. All that we did, and he said this in writing, all that we did is the attached regulation, which is a competition exemption, which allows tenants as a group to negotiate with landlords for rent reduction. So the DTI said this is why we implemented the block release. Now, unfortunately, the landlords are not respecting the block release. And unfortunately, what the landlords did is that the three associations, which is SAPOA, the SA Rights Association, and then the South African Council of Shopping Centres, got together and they came out with an offer. And the offer was directed at the large tenants. And why? Because the large tenants were telling the world through the media that they weren't going to pay rents. So the landlords got together and they created this offer. And by the way, that offer that they created defines small businesses as businesses doing 80 million Rand or less. So they were not talking about you guys when they said they were talking to tenants, because most of you are doing 5, maybe 10, maybe 20 million Rand a year turnover, maybe 30 million Rand a year turnover in the luxury market, but certainly not a hell of a lot more than that. But you were nowhere close generally to the 80 million Rand a year turnover, unless you were like the really big guys. But the landlords got together And so those three associations, and this is not me talking, this is them talking, they called themselves the pigs, the PIGS. I thought that was so appropriate. They called themselves pigs, the property industry group. And so those three associations created pigs and came out and said, here is our offer to tenants. You see, we're the good guys. We're giving 350 million rands worth of discounts in rents, and we're making sure that thousands, if not hundreds of thousands of people don't lose their jobs. All a lot of rubbish, but they went on a charm campaign with the media. The media believed them, wrote about it. And suddenly tenants were made to look like the bad guys if they were rejecting the offer by the landlords. But the landlords had not sat at the table with tenants and negotiated what should go into that offer. So it was unilateral, it was one-sided. And until CITA was created, or rather until CITA said, right, we want to now get involved, and started conscripting small independent tenants, and we've got about 700 of them now as our members. But until CITA started, it was totally one-sided. The landlords got together as a group. They created an association, a confederation of their three associations, and they came out with their offer. And then they turned around to the tenants, and they said to the tenants, we're not going to allow you to join an association. We're not going to allow the association to negotiate leases on your behalf. We're insisting we're dealing with you individually so we can bully the hell out of you. And then we're insisting you sign a non-disclosure agreement so that you don't tell other tenants what it is that we've given you, which is completely contrary to the block release that was published by the Department of Trade and Industry and what Mohammed Vorda had said, which allows tenants as a group to negotiate with landlords for rent reduction. So landlords were acting completely contrary to why that block release was published by Minister Patel. But the reality is that DTI have turned their blind eye. They've looked aside because the labor, the property portfolio group is very, very powerful. They've got a number of politicians in their back pockets. And that's why you've got such anti-tenant regulation and legislation in South Africa to begin with. Sorry, there was a comment by Lorna that says Jewellery Council obtained some standard document which will be circulating to members to utilize in their business. Oh, beautiful. That's fantastic. Thanks for that, Lorna. All right. So CITA, we've approached landlords on behalf of our members, either collectively or individually, on behalf of tenants around the country. And we've got a four-legged approach, if you want. The first is, if this is jewellery, we're saying that we want the landlords to recognize that CITA and the Jewellery Council represent retail jewelers and manufacturing jewelers and want to negotiate a better deal for them in terms of their leases now, but also their leases going forward. If you signed your lease in your own name, not in your business's name, and if your business has a net asset value of less than 2 million rand, and if for whatever reason you're feeling that you want to get out of the business now and maybe come back again in 6 months or in a year's time when the retail sector has been reestablished, so you want to get out of your lease, then if those are the criteria that are satisfied by you in your particular situation, we can invoke what is called the Consumer Protection Act. And the Consumer Protection Act will allow you to get out of it with 20 days notice. You most probably have to pay a 10% penalty of what's remaining in your lease, but you can get out of it. So that's the second leg, the application of the CPA. The third leg is that what we are trying to do is pressurize landlords into moving away from charging a set rental for size and moving towards a percentage of turnover rather. And what we're saying is that if you charge a percentage of turnover, you're sharing risk. So while we're locked down and we can't trade, we're not going to pay anything in terms of the percentage of turnover. But once we're trading, as business gets better, we're going to pay you more and more and more up to a maximum. And the maximum can be 7% or 10%, whatever it is. Because that way risk is shared. Whereas at the moment, whether we're trading or not, we have to pay you a lease, the rental on a lease. And whether we're trading or not, we have to pay you a fixed rental, irrespective of what turnover looks like in our business. And it doesn't suit us. And the final thing that we're campaigning for around the country is this. We want a reasonable exit clause. We want, and this is most probably where we're going to have to go to the Portfolio Committee on Trade and Industry and get law written in this country so that it becomes a right of every retail tenant, you know, under the category of, let's say, 40 million rand of turnover. It becomes a right for you to be able to cancel your lease with nothing more than 2 months or 3 months notice. Why should a landlord be able to expect you to pay out for the balance of the lease, which could be 2 years, if you want to move out of the business, when in fact there is no enrichment you can be benefiting from? It's absolutely unjust enrichment on the landlord's part. So we're campaigning for these things. It's not going to be easy. It's a big hill to climb. And we know that we cannot match landlords and managing agents in terms of legal power. So we know we have to go with trying to get society to back you as small retailers in getting landlords to buckle, number one. And number two, getting government to implement better law in your favor as small business people. And it's an uphill battle, we know that. But we think it's a noble cause which is worth fighting for. And Lorna, I know you and I have spoken, and I hope you will continue to say that, you know, it's worth us engaging and working together towards these ends. Okay. Now, Department of Trade and Industries. Sorry, I just want to go back there. Oh, there's something very important in the first slide that I actually skipped when I went over the disaster management regulations. And that is this, the Temporary Employee Relief Program. Now, basically, all of you are locked down, which means that all of your staff should have been laid off in terms of the law of the country. And being laid off, what that means is that you wrote a note to them to say, "Dear Harry, thank you for being such a loyal employee of my business. As you know, we're locked down. And so that we can get some money for you to be able to pay you, Harry, we are going to have to inform you now that you are laid off from this business until we reach level 1 or level 2, when we can reopen a retail business. And then, of course, you will be reemployed. Because you are laid off, we as a business are entitled to apply to the Unemployment Insurance Fund on your behalf, apply for TERS, which is temporary employee relief, because of the fact that you're laid off. And you will be paid anything from a sliding scale at the lower levels of what you earn, from 60% of what you earn, to the higher levels. For the first 17,720 Rand of what you earn, you'll be paid 38% at the most highest level, 17,720. So if you earn 20,000 Rand a month, Harry, you will be paid the equivalent of 6,750 Rand, which is 38% of 17,720 Rand, which is the maximum ceiling we can claim against for UIFTER for you. If you earn 3,500 Rand, Harry, you will be paid 100% of your 3,500 Rand. But if you earn 3,501 Rand, you will be paid 60% of that 3,501 Rand. So that's the way that the UIFTER scheme works. It has been problematic for the last 2 months. Some companies have received TER money. Other companies have not received their TERS payments. And what makes matters worse is that the Minister of Labour, and he announced this on the weekend to the world, he said employees can now go online, type in their ID number, and they will be able to find out how much money we paid back to the employer and when we paid that money. Now, that would be all right if it was true, but it was a lie. The Minister of Labour was lying to the employees, because if an employee goes online and types in his ID number, if a company had applied for TERS for 10 people and the UIF had paid back a little bit of money for one person, then what's online is that for that company, the UIF have paid the company, here's how much money they've paid the company, and this is for everybody in the business. So it's creating a huge amount of consternation, particularly amongst unionized employees, because the employees are calling the employers liars. And that was the intention of the Minister of Labour, to set employees up against employers and divert attention away from the fact that the Department of Labour is completely useless. In fact, they're fraudulently useless in what they're not doing. And in the process, they're deceiving the South African public and employees amongst the South African public. So can I ask you, is there anybody online who in fact has got TERS? Is there anybody online who has questioned how TERS has in fact operated?
Ivor, can I ask a question?
Of course you can.
In relation to the claims that we will be able to submit for May, will we only be allowed to claim for staff that was completely laid off during the entire month of May, or will we be able to claim for 50 or 30% reduction during May?
No, so your staff are laid off. You do not claim for TERS if you've reduced their hours or something like that. There can be some staff who are working and some who are not working. So the ones who are not working, you will claim TRS for, and the ones who are working, you can have said to them, you're only going to work half day. Then the employee can go back to the UIF and claim for reduced hours, which is a separate insurance policy on UIF.
Yeah,
can only be claimed for by the employee, not by the employer.
Themselves. Thank you, Ivor.
Right. Any other questions?
Yes, Ivor. Tanya from Dora Jewellers. I have 9 members of staff.
Yes.
And I've only been paid 20% of my staff salaries.
Right.
Now they're claiming that my other 70% or 80% are not registered. So I'm now liaising with my accountant to find out what's going on, because I know for a fact that they are registered, they've been paying UIF all the years, and I've only been paid 20% of staff salaries, and I've laid them off. I've closed the workshop and the retail because I've got them both.
What I'm very happy to do is send through to Lorna the name and the phone number of Carol Salito. Carol is someone I use for a lot of my clients. I don't know how she does it, but she has a line. She has a line directly with the UIF. She's got people there she talks to, and she manages to regularize a whole lot of things, including, by the way, the fact that what we found is that a number of employers have paid the money, the UIF money, but not for a particular person. Sometimes they've replaced the person, continue to pay the UIF, but for the original person who's now left the business. And so all of that might need to be regularized in the process. Now, remember, you've got an entire month to sort the niggles and the problems out so that when they do pay out, you've sorted the niggles and the problems out. Also, remember this, if you weren't paid out for April, you can still claim for April. And if you register your claim online on the system, then in fact you will be paid out from the beginning of when TERS was applicable, which in fact was from a couple of days at the end of March. Now, what that does for you is when they do pay you out, when they have approved the payment, you'll actually find out that you're going to get 35 days payment for April, not 30 days payment for April, because they're paying you out for the 5 days from March when in fact TERS kicked in. Now, the good thing, of course, is once you've got your claims sorted out and you've been paid once, you just need to submit back proof of the fact that you've paid your employees either before or after you've received TERS. And that's a change in the law, by the way. And they will automatically make the second payment to you. You don't need to claim for the second payment, and you don't need to claim for the third payment. So April, May, and June are the periods that TERS applies. And once you're registered, you'll be paid out for TERS as long as you've got proof that you've paid the TERS over to the employee. You'll be paid out for April, May, and June, and you don't have to keep reapplying. But I would really recommend that I'll send Carol's number to you, Lorna, and then my recommendation is you just send it out to your members and let them get a hold of Carol and see what she can do for them. What you can also do, by the way, is if you go online to the UIF TRS system, ladies and gentlemen, then you will find that there are 2 buttons eventually that you will get to. The one is green for the claims which are successful, and the one is red for the claims which have been rejected. You click on the claims which have been rejected, and it will give you a reason for why they've been rejected. What I can also tell you is that if your employees are foreigners, not South Africans, if your employees are foreigners, and you've been paying UIF for them for 2 years or 10 years, doesn't matter, that ordinarily they have not paid out for foreigners unless you sign the UI-19 form and fill that in and upload that. And that's also something that Carol can help you with, or that you can do individually. But what we're finding, funnily enough, is that your accountants and your bookkeepers are struggling for whatever reason, but they're struggling to get these claims approved. So please just, feel free. I see that Jennifer circulated the TERS link, so that's fantastic. Thank you, Jennifer.
Ivan, may I ask a question, please?
Of course, Chris.
So just,
of course.
just to clarify, so for the month of April, we sat at home and applied for TERS. We were paid. So now, in the process of opening again, so if we bring back a third and a third and a third, and eventually over a month's time, everybody has come through, they're entitled to payment from the company. Is there then a different approach to the UIF once you've paid part of a month or a salary or
Chris,
any form of contribution?
I need to disabuse you of a notion, and that is this. The moment you open, the moment you step out of lockdown, besides the fact that the moment you open, you activate your lease agreement with your landlord in its complete form, or in terms of the previous offer that your landlord might have made you, besides that fact, the moment you open your doors and you invite the employees back to the workplace, whether it's on a reduced basis or on a complete, 8-hour-a-day basis, you immediately cut off your access to UIF TERS, because the TERS scheme has only been implemented for companies in lockdown where employees have been laid off. So in the four-stage process, in the four-stage process of reopening your business, what will happen is, and I'm just going to use the May as an example. Let's say on the 4th of May, let's say you employ 100 people, just for argument's sake. On the 4th of May, you bring 10 of those people back to clean your workplace and to set up your SOPs, etc., etc. Those 10 people you bring back from the 4th of May will not qualify for TERS. And let's say you then bring back the first 33% on the 11th of May. You will be entitled to claim TERS for those people up until the 10th of May. Let's say you bring back the second group of 33 on the 18th of May. You will be able to claim TERS for those people up till the 17th of May. And then the final group you bring back on the 25th of May, you'll be able to get TERS back for them up until the 24th of May.
Okay, then a question. So will you not be entitled to claim UIF under short time?
Yes, of course you will.
For the balance of the income.
Right. So here's the next stage, and it's what I said a little earlier. What I said a little earlier was this. Of course you will, but now it's different. Remember that the UIF is an insurance company. It's not one insurance policy. So the UIF is an insurance company that offers a whole variety of product. One of their products is if you're sick, you can claim UIF. If you are fired or retrenched, you can claim UIF. If your hours are reduced, you can claim UIF. So those are 3 additional policies in addition to TERS. TERS was originally a scheme which was available to companies that wanted to retrench people, to give them money to retrain those people before they retrenched them. And it was morphed now into TERS. But it's one of 4 or many more policies which are available from the UIF. The only difference between TERS and the other policies is that TERS is the one that the company can claim for on behalf of the employees, whereas all of the others, only the employee can claim in their own right from the UIF. So the employer would give him a letter to say, we've reduced your hours by 50%. So instead of paying you 10,000 Rand, we're only paying you 5,000 Rand. And then he can go to UIF and say, for the 5,000 Rand, I'm not paying. Can you apply the sliding scale of UIF and give me something to compensate me for that 5,000 Rand loss, because I've got an insurance policy with you. It's called my UIF contribution. And here's 10 years worth of proof that my employer has been deducting half from me and paying the 100% UIF subscription on my behalf for the last 10 years. And therefore, it's my entitlement. I'm entitled to it from the UIF. But it's only TERS where the company applies for TERS. Everything else, the employee has to apply.
Ivan, so can I then just, sorry, I had to step out for a few minutes, so I missed the beginning of the TERS presentation. So my employees, are they entitled to, they're obviously entitled to TERS under the conditions, and at the same time, are they entitled as individuals for their balance of loss of income to apply to UIF?
So one individual won't qualify for both TERS and reduced hours. So it's either TERS, I'm completely locked down, or it's reduced hours. It cannot be both.
But now about April under lockdown, so they got a percentage under TERS,
yes,
of their total income.
Yes.
Provide, say the company cannot pay them any salary in that time. Are they able to claim UIF as individuals outside of TERS as well?
No, they won't qualify for both TERS and everything else. It's only one or the other.
So now then the insurance company is getting away with this because now TERS is taking up the slack of no income. Sorry,
just say that again?
So TERS is now, the money, TERS money, it doesn't come from this insurance policy, the UIF money.
No, well, it does.
It's a different fund.
No, no. So there's something like there's something like 100 billion Rand sitting in the UIF. All that government did was say, of that 100 billion Rand, let's take 40 billion and let's put it into TERS. If we go beyond that 3-month period, we'll then take more money and expand it for as long as the lockdown's going to last for those companies that are still in lockdown.
Okay, all right. Sorry, I like I say, I've missed a few minutes there. I understand.
Excellent. All right, no, that's very, very good. Thank you for that. Any other questions before I move off of TERS? I hope, ladies and gentlemen, I'm not boring you. All right.
No, not at all.
Okay, good. Good. All right, so slide 3 really has to do with the fact that, and it really doesn't benefit you in the short term, but rather in the long term. With the earlier discussion we had, Lorna, when we spoke about the notion of a proper export council and export strategy for jewellery, manufacturing jewellery in particular. But basically, it's about the fact that I'm saying to you that the Jewellery Council needs to think about itself, and I'm quite happy to work with you in this regard. Also about the fact that you're a trade organization and you're an employer association. A trade organization meaning that you are lobbying for better trade dispensation with government, and you should be asking the questions, why are you allowing jewellery in from overseas when those countries don't allow South African jewellery in without putting up huge hoops and giving their own manufacturers huge incentives? Why are we not having those incentives in South Africa for our own manufacturers? That should be a question you ask. And you ask that as a trade association. As an employer association, you've got to be very, very careful here. Because as an employer association, you do not want to run the risk of being sucked into a bargaining council, either because you're going to be at the table of that bargaining council, or in fact, you're going to be treated as a non-party in a bargaining council without being an employer association, registered employer association, so that you are master of the fate of your businesses and you're master of the destiny of your employees. And we can talk about that at another time. But I'm suggesting that's critically important in your relationship with the Department of Trade and Industry, because those industries that have had effective trade organizations and effective employer associations have been able to march into the DTI and demand a whole lot of additional things that ordinarily retailers, etc., have not been able to demand. For example, there have been aid and relief packages which have been created for specific industries. So, for example, the call center industry has its own set of aid and relief packages, just as one example. Construction sector is getting its own aid and relief practices equally. And all I'm trying to say is I think that retail and manufacturing jewelry should be at the front of the queue as far as the DTI is concerned. And I think the DTI sometimes gets away with murder because the industries themselves don't feel empowered to always ask. And so I would like to work with you in that regard and make sure that that problem is a problem. And I'm talking completely out of hand here, so forgive me. But if it is a problem, I'd like to work with you, making sure that it's no longer a problem. Okay. Questions and answers, ladies and gentlemen, about anything I've said. Howard says, if your store is very dependent on tourist trade, would you recommend not reopening your store until international borders are open and a turnover percentage deal? Howard, I completely agree with you. If that's the Howard I know, then certainly at the end of the market that you deal with, to open your store now. I mean, I went to Eastgate yesterday and it's absolutely mothballed, except for Discam and Pick and Pay, etc. So to open your store where you are immediately saying that we're going to completely trade as we normally do in this business and therefore agree to pay our leases, the full rental value of our leases, or at least what the landlords offered us the last time around, and to bring back even 30% of your employees is ridiculous, given that your customer base is not going to be in this country till at least August, September, if you're lucky for the December trade. So you need to be negotiating a completely different dispensation with your landlord to be able to survive. And I think it's critically important for you to understand. Deepika says, please can you recap on what document would be required to deliver products to customers? Well, Deepika, I think what I'm going to do is I'll work with Lorna. We'll draw up a memorandum. We'll try and get examples of the documents in terms of how you should complete them. We'll also try and get an agreement from the DTI to allow e-commerce trading for those businesses which are retail jewelers. And as far as the manufacturers are concerned, we will try and get the DTI to give a supporting letter so that if you are ever approached by policemen or the Department of Labor or whoever, you've got proof that you fall into those categories. What could also be used, Lorna, is for you to visit your local police station and say, you know, you're from the Jewellery Council. These are the essential service alert level categories you're justifying the business under. Here's a letter from DTI. You want the station commander to give you a permit that can then be given out to all Jewellery Council members, so that at least when the police raid you, you've got the supplementary documents. And also, if you then send someone out to deliver, whoever is going to deliver on your behalf, if it's not a professional courier company, then just carries that permit at the very front of the windscreen. So that no one can stop you and no one can give you any kind of trouble. So I hope that answers the question. Claudine said, Mike, I see your question. I will try and answer your question a little later. Claudine says, are we as retail jewelers able to open at level 3 or 2? I think it's level 2, Claudine. Should jewelers be allowed to trade in stage 3? We have security concerns with few retailers opened around us in the mall. Should we choose not to open? What rights do you have negotiating with the landlord? Well, you're fully entitled to, you set preconditions to your landlord. You're saying to your landlord, you know, if it's a social pension fund, for example, you're saying to them, I bought a lease from you based on footfall, foot traffic, security, lifts working, escalators working. And because of what's going on with COVID, none of those things are happening. So you, landlord, are in breach of your lease with me. You are sending me a rental statement or a rental invoice in bad faith, knowing you're in breach of your agreement with me. You're in breach of the lease you signed with me. And I'm not paying those things. This is what I want to see in place before I pay anything. And then when I pay, it's going to be on a percentage of turnover basis. Those are the discussions you should be having with your landlord. But unfortunately, majority of us do not feel strong enough to take on the managing agents of the landlords. Unfortunately, most of us feel like your landlord is doing you a favor, allowing you to trade in his center. which is absolute cogswallop rubbish. I can tell you for a fact that Dion's are not paying rent. They've not paid rent for 10 years. They're paying water and they're paying lights, and they may be paying a percentage of turnover for the good months. But they are a tenant the landlord has to have in the center because they're a destination tenant. So they're making exceptions. But who's doing the monthly payment? Where is the monthly cash flow coming from for the landlords? It's from you, the small independent tenants. The bottom line is you have rights. And what SITA is saying to you is start exercising those rights. Because if a landlord makes you angry, I nearly said something else, but if a landlord makes you angry, you can move to other shopping centers and set up, and your clients will understand, particularly if you make your clients understand why you're moving. We're moving because our landlord was criminal. We're moving because our landlord was greedy. And the point, and that's a leg of SITA's campaign. It's to get your clients to back you and to say to your landlords, if you don't give a good deal to your retail tenants, we will vote with our feet. We will stop shopping in the shopping center. We'll go to another shopping center. And what SITA is doing is it's implementing a grading system for the landlords who are playing the game. Not our game. It doesn't have to be meeting every one of our requirements, but playing the game, prepared to engage. And the landlords who are just not playing the game and who are literally criminally abusing the small independent retail tenants. There's no other way of putting it. All right, guys, thank you very much. I realize that I've gone massively over the original time that we indicated. Well, not massively, 15 minutes. I do apologize for that. I will send the recording of this webinar. I will also send the regulation that I referred to, and I will also send Carol's Solito's contact details for those of you who might need her for your TERS engagement with the Unemployment Insurance Fund. It's been an absolute privilege chatting to you, and I really want to thank you for the opportunity. So Lorna, thank you very much, and Debbie, thank you for introducing me to Lorna.
Thank you, Ava. We really appreciate your input, and thank you for your offer to work with us as well.
That's what I'm here for. Thank you so much.
Thank you.
Bye, guys.